for being here today. It's an honor to be here with you. Mr. Verrilli, I just had a few questions for you. Do you believe that it's the duty of the Solicitor General to advance the political agenda of the President?
No, Senator. I don't think. I think the duty of the Solicitor General is to advance the long-term institutional interests of the United States, and it's not a partisan job.
So it's possible that those two things can conflict, the political agenda of the President on the one hand and the legal obligation to the United States on the other?
Well, I think it's partisan considerations really should play no role in the judgment that a Solicitor General makes.
Okay. And it should be based on your understanding of the law, your ability to convey arguments to the Supreme Court based on the law, based on the Constitution, and so forth. Is that,
certainly.
If, as I understand it correctly, Attorney General Holder sent a letter to House Speaker Boehner explaining the decision no longer to defend DOMA. And in that letter, Attorney General Holder explained as follows. He said, previously the administration has defended Section 3 of DOMA in jurisdictions where circuit courts have already held that classifications based on sexual orientation are subject to rational basis review. And it has advanced arguments to defend DOMA Section 3 under the binding standard that has applied in those cases. So he acknowledged that Department of Justice attorneys had defended DOMA Section 3 on that basis, on the basis that rational basis review would apply. Is that your understanding as well?
I have read the letter. I think that is what it says.
Okay. And then the letter goes on to explain why he believes that that's not the appropriate standard, that heightened scrutiny ought to apply rather than rational basis. He goes on also to conclude that there's no reasonable argument that can be made to defend DOMA Section 3 under the rational basis standard or otherwise. So my question for you is, if the Department of Justice has defended a law that it later determines to have been so unconstitutional that no reasonable argument can be made in defense of it, does that mean that the Department of Justice attorneys who previously defended that law acted unreasonably?
No, Senator, I don't think so. I mean, you know, these are quite rare circumstances, but they do arise, and they really have arisen in most administrations. There's an example that when Paul Clement, who was a superb Solicitor General, was here for his confirmation hearing, he described a case involving a law that this body had enacted which had prohibited bus advertisements favoring the legalization of marijuana for transit systems that had received federal funds. And that was a case that the Department of Justice had defended in the trial courts. There was a constitutional challenge to it, and the Department of Justice defended it in the trial courts, did its best. And as he explained to this committee, that when he looked at it, he just made a judgment that applying the traditional standards, that you just couldn't mount a reasonable constitutional defense for it, and so he changed. And I don't think that implies anything about the judgment of the lawyers who had previously handled the case. And I think these things are really tough, and people make the best decisions they can. They apply the standards, they act in good faith, they take it seriously, they wrestle with it, and they do their best. So I don't think it implies anything one way or another about the reasonableness of the prior judgment.
Although here they're disagreeing not only as to the ultimate outcome, as to constitutionality, but as to the standard that should apply. And they're arguing that no reasonable argument could be made that rational basis scrutiny would govern. That does seem to me to require a certain conclusion as a condition precedent to this decision not to defend it, that those Department of Justice lawyers who previously defended it acted unreasonably in their defense of DOMA.
Well, you know, because I was recused, all I really know is what's in the letter. Having said that, I still don't think that I don't think I would reach that conclusion, because these are tough decisions and people act in the best of faith and they make judgments that they think are reasonable.
Sure, sure. And they sometimes make policy judgments. And it appears to me that this was a policy judgment made by this administration, that although previous administrations had defended the law, the Clinton administration, given that President Clinton signed it into law, the Bush administration, and even the Obama administration had defended it, that for policy reasons it was no longer going to defend it. But do you believe that a change in policy, in a political calculation-based policy decision should affect the way the Solicitor General operates in deciding when, whether, and under what circumstances to defend a law?
So with respect to this decision, because the Doma decision, because I was recused, as I said, all I can say about it is based on having worked with the Attorney General and having worked for this President. And I do have confidence, Senator, that they wrestled with it, understood it was a rare circumstance and a grave decision, and made the best judgment they could on the law. And I think if I were confirmed as Solicitor General, I can assure you that decisions I make will be made on the law and not on partisan considerations.
Senator Franken.